surpassed Vicky Nadorf and Dave Hammerslaw. We are continuing to welcome guests, and so we will start momentarily. As you will see, thoughtfully, Vicky has made a curated deck of slides available for attendees who are in the meeting. And if you would like this slide deck over the next few days, please email me, pcardis@silvar.org. That is the only way to obtain a copy of these sort of snazzy new slides. Vicky had just come back from Disney World in Florida and has got her Star Wars vibe going today, you'll see.
Yeah, I'm a bigger space cadet now than I was before.
So people are still coming in, but it is now approaching. Oh, I'm already getting emails, Vicky. Slammed with emails. I'm going to turn off the sound on my phone so that it does not distract. Shall we begin?
Anytime.
Or do we want to wait? People are still joining. Oh, there's lots of folks. Yeah, I see them all.
I just want the popcorn concession.
You want the popcorn concession? Oops, I need to turn this volume off. And they're still flowing in.
What are we expecting here today, Paul?
Well, you know, we register the capacity for a webinar is 500, and the CAR guideline is that you should expect about 60% of those people to actually show up. So we were oversubscribed. I took a walk on the wild side and let in more than 500 people, but you know, I would think that we'll probably wind up in the 300 or 400s. If you will recall, Dave, when we first did this, when Vicky first helped us arrange this during COVID, we once again had the 500 person cap, and we let in 650 people, and we had 600 show up. So Vicky and you agreed to do a second seminar that year for another 300 people, which makes it still the most popular event in COVID or post-COVID world on Zoom that we have done at Silvar. So sort of learned our lesson then and tried to be a little more cautious. There's still a wait list of people, and perhaps once we get going, I'll go and let them in. So if we're ready, before I introduce our speakers, who really need no introduction, I want to again welcome you to the fall 2022 Silvar Legal Update put on by your association. We appreciate your membership, and we are most grateful for the expertise, knowledge, and intellectual heft that Vicky Nadorf and Dave Hammerslaw bring us as counsel to PRDS, which is Vicky's role, and as counsel to the Silicon Valley Association Board of Realtors, which is Dave's role. But they do not work in a vacuum, and they do not work alone. And so I would like to start off by thanking the members of the PRDS Forums Committee. So in addition to Vicky and Dave, we have Mark Burns, Dave Ziegel, John Till, Louis Kappen, Joanne Wondolowski, David Bergman, Carolyn Miller, Carol Burnett, Ron Gable, Jan Jaramillo, and Catherine Tomino. You will notice that these are all well-known brokers and producing agents from both the San Mateo County and Silicon Valley Association of Realtors. They meet twice a month, every month for the past year. In fact, they're meeting tomorrow afternoon at 2:30. So we thank them for their service. We thank them for the experience that they bring, and we thank them for helping us build a product in PRDS that we believe is second to none. So first, I will start off, and I'll try to be brief. I promise I'll be brief by introducing Vicki and Dave. I've probably said this many times, but it bears repeating. Vicki Nadorf is probably best known for her service as Vice President and Brokerage Counsel for Coldwell Banker, where she kept approximately 5,000 sales associates out of trouble. Now she tries to keep 9,000 realtors in Samcar and Silbar out of trouble. She is of counsel to Broker Risk Management, and she has the unique distinction of being the only person who is on the three major forms contract committees for CAR, the San Francisco Association of Realtors, and PRDS. I think I would not be overstating it to say that Vicki is the author of most in-house transaction forms that were used at Coldwell Banker, and she is the intellectual force, not just behind PRDS, but any part of the CAR contract or PRDS contract that you use every day has Vicki Nadorf's fingerprints, her opinions, her blessings, or her curses on it. So we are pleased to have Vicki with us as always, and she is most importantly to us PRDS counsel. Dave Hammerslaw, what can we say about Dave? He is counsel for the Silvar Board of Directors. He has been in practice for 40 years, litigating and arbitrating residential and commercial real estate disputes on behalf of brokers and agents, buyers and sellers, landlords and tenants. He teaches courses, writes articles on subjects, which you can see monthly in Silvar, the legal update, the legal corner. And he is also an active mediator or an arbitrator of real estate disputes. Vicki doesn't practice in court, so if you know, I've already said that anytime that I need to saddle up and go into court, I want Dave alongside of me or driving the wagon. So without further ado, I've already taken 5 minutes of your time. I'm going to turn this over to Vicki and Dave.
Thank you so much, Paul.
Thank you.
We have a really good program for all of you today. As usual, we will not be able to take questions during the program. You are certainly free to send questions into Silvar after the meeting, and to the extent that we can respond, we will do so. Today's program is going to focus on, first and foremost, new and improved PRDS forms. We will also be reviewing the latest news on the CAR, RPA, and other CAR forms. We'll spend some time talking about new laws, but in my opinion, the best part of the program is the section that I call It Ain't Necessarily So. It's a musical tribute to things that you may think are true, but actually aren't. PRDS is going to be rolling out 8 new and improved forms. All 8 are already on Zip and Glide, and we hope to have it on our 3rd platform if Lone Wolf will only cooperate with Paul's efforts. The 2 new forms are both in connection with new construction. The first is a new construction purchase contract, the NCPC. The second is a new construction options and upgrades addendum. PRDS NCPC, it mirrors the PRDS purchase contract, the REPC. It's been specifically tailored, however, for use with the infill type of new construction that is prevalent in PRDS territory. Highlighting differences in this new contract is my esteemed friend, Dave Hammerslaw. Dave, take it away.
Thank you, Vicki. Well, if everybody would take a look at what Vicky has highlighted up at the top, which is a note that the committee spent time working on to spell out as clearly as we could what type of new construction is contemplated to be used with this form. So this is not intended, I stress, not intended for use with subdivisions, subject to review and approval by the DRE. And it's also not intended to be used with existing structures that are being or have been remodeled or renovated, and or where a portion of the prior structure is being used as part of the new structure. So we spent some time debating this. We felt that for what use we think is best in this geographic area, the contract is only to be used with completely new single-family construction. Now, I do want to caution you that we have the Right to Repair Act. Many of you refer to it as SB 800. There are unanswered questions about that law, in spite of the fact that it went into effect on January 1st, 2003. Many of you will remember that I had a very healthy head of hair in January of 2003, which I no longer have because of that statute and others. The bottom line is this. Because there are some unanswered questions about if you incorporate, for example, part of an existing foundation or not, whether that is or is not under the Right to Repair Act, just bear that in mind. But the expected use of this is when you start from the ground up completely. The second thing is that we have in paragraph 2A, a close of escrow date, and the definition is tied to a certificate of occupancy, or you'll notice, or other comparable final government documentation. Many of us use the term certificate of occupancy, but some jurisdictions use certificate of completion. There are many different terms, but that is the concept that we are stressing here in the close of escrow. And you have a choice there of filling in a particular date or no later than 10 days after the buyer receives written notice from the seller of the issuance of that type of final government approval. The next thing that we would like to focus you on is possession. And these are one of two sellers' obligations. So delivery shall occur at the close of escrow or on a specified date, unless otherwise agreed in writing. There are certain obligations that the seller needs to meet that are spelled out in that paragraph. And the allocation of responsibilities with respect to a deposit for an HOA association to obtain keys has also been spelled out. The other one that is certainly critical is the, hang on, Vicky, the seller's completion obligation. And that spells out what the seller is required to provide. It does have a delay provision in it. And you will also notice that it has a specific clause which repeats itself, and we'll pick up a little bit later, that if there are issues about the completion obligation, then we want the parties to institute mediation immediately. So Vicky then had put up changes in construction from the property description. This is designed to address the situation where you've got pictures, depictions, descriptions of some sort, whether written or oral, regarding the construction and whether or not they will be incorporated into the finished product. This is what that is designed to address. So pay attention to that. And then we have a paragraph here entitled optional items. We've got upgrades, we've got color and option selections specified, and it references the options and upgrades addendum, which we will be highlighting and bringing to your attention here at the end of the discussion about the contract. So moving on, we have obligations that are set forth in the particular contract. You will find them in paragraph 11. They've been highlighted here. The standard disclosures, including insulation, are covered in 11A and 11C. We do address the issue of public reports just in case, you know, there is a need for that. And then we have the obligation of a seller to disclose known material facts it always bears repeating to include that. And then that includes insurance claims within the past 5 years. And then here's one thing I would like to bring to your attention about known material facts. If there are city inspections and repairs are required by the city, please bear in mind the disclosure of that history of what has taken place. So we don't have a situation where it's like, well, we didn't have anything that needed to be fixed. There's always things that need to get fixed and changed because of some issue. So just bear that in mind. Then we also, as a committee, spent time talking about F, which Vicki has starred, the seller's requirement to disclose a list of all design professionals, suppliers, contractors, and subcontractors. We as a committee felt that this information was important for a buyer to have. I also want to point out to everybody's attention, you ought to be considering which one of those contracts that are with those particular personnel are assignable or not assignable. Why? Because it gives you another quiver of rights other than a standard claim under the Right to Repair Act and or for negligence. But we had some dissenters on our committee. I love them still, but we overall said we did not feel that this was an invasion of somebody's privacy or their personal group of people, because the buyer should know who was involved in that respect.
Dave, I have a question for you. It relates to the star that's next to paragraph 11F. Is that particular provision in the car new construction purchase contract?
It is not, nor are there provisions. If you go back to the section about seller's completion obligation, you don't need to go back to it. I want everybody to read this because as a committee, we really discussed what standards a seller's completion obligation ought to include. And we did include something that we feel is important and broader than what is in the car contract. All right, we are now moving on to natural hazard zones. So the zone information is there if an NHD is not required. We have the Prop 65 warning with the advice to obtain where to obtain more information. And then moving on, we have dispute resolution. Aside from mediation and arbitration, this is where we get into the Right to Repair Act and the need to initial this if you are not going to be governed by the act. And I would stress, please, when these choices are being made, if you and your client don't have a good understanding of this, please consult with a qualified California real estate attorney on these issues. There are significant issues here that need to be taken into consideration. The non-adversarial procedure set forth in paragraph 25 is another one of those options. And once again, these are not paragraphs that should just be automatically initialed, or not initialed. You really need to have a discussion of what is the significance. Part of it may turn on whether the developer / seller is or is not a builder and therefore falls within the act or not. There are a number of issues here that just need to be thought through, but here's the area where this takes place. Moving on, Vicki, to seller's warranty. This is also another area where I urge you to take the time to make sure your client understands what they are or are not receiving, opting into, what are the consequences and ramifications of it? Does the act apply or not apply? And again, the problem we have is we have a law that just has not been interpreted in a lot of respects, even though it's been on the books, as I said, effective January 1, 2003. We have a provision in here for limited warranties, That may or may not apply in certain instances, so just recognize that. But if somebody is presenting your client with limited warranties, please stop and have somebody that understands this act and their rights and remedies evaluate what is in their best interest. We also then included the manufactured products, maintenance and warranties, and the requirement that those be transmitted from the seller to the buyer. There's a lot going on, ladies and gentlemen, in this statute. There always has been, and it just bears slowing down and making sure the client understands what rights they're really receiving or not receiving. And then we came up with an options and upgrades addendum. The options and upgrades you will see are identified on page 2. There is a column for there with prices. There is language in the purchase contract that addresses whether the purchase price is adjusted depending upon whether the options are paid for or not, by the buyer. That is certainly something that you can negotiate. The option payment does become part of the liquidated damages clause, which is fairly typical in these types of contracts. We have a liquidated damage provision that applies to disputes relative to those particular issues. We worked hard to try to come up with a concise document that provided the information that we thought needed to be on this in order to supplement these choices. Vicki, what other revised forms do we have in our quiver?
Well, we took care of 6 of our forms.
6? Wait a minute, are you kidding me?
Yeah, we did 6 revised forms in addition to the 2 new construction forms. And 6 is a good number. We revised the real estate purchase contract, the cancellation of contract, the intent to exchange addendum, the basic addendum form, exempt seller disclosure, and my personal favorite, the San Mateo, Santa Clara County disclosure. I'm going to take you through the changes to all 6 of these forms. REPC. Well, actually, we took a look at what we had done 2 years ago, and we felt that very few changes were needed. In fact, only 3 changes were made to the REPC. First, we created as to which disclosures are required if the seller has to fill out TDS. We came up with a specification of the effect of the buyer failing to make agreed upon deposits. And we tackled something which just recently has come up in several courts, eliminating the debate regarding broker participation in arbitration. So let's start off with paragraph 10. Most of you who use the PRDS REPC are very familiar with this paragraph. This is the paragraph that details what statutory disclosures have to be made. We took a long look at this, not to change it because of any new laws or new forms, but to see whether or not we could make it clearer as to precisely what is needed. We therefore broke down what was one entire sentence into subparts. So it's now clear that unless the seller is exempt by statute, the seller shall fully complete a TDS and NHDS. If the seller does have to fill out the TDS and NHDS, the seller shall also complete a lead disclosure if the property was built before 1978. The seller will also provide a disclosure regarding fire hardening if the property is in a high or very high fire hazard zone and the property was built before 2010, along with a statement of features that make the property more susceptible to wildfires, and provide any final inspection report that may have been generated pursuant to the government. Also lists that a defensible space disclosure must be provided if the property is in a high or very high fire hazard zone. If the TDS is required, the seller shall also fully complete the SSC. Now, all of these forms generally are provided to buyers as part of an upfront disclosure packet. If that is the case, PRDS continues to provide a checkbox system so that the buyer can acknowledge receipt of the fully completed TDS, SSC, NHDS, lead disclosure, and the fire hardening defensible space disclosures. This is one, I believe, of the real advantages that PRDS recognizes how the marketplace works in this territory and allows you to show that the buyer has already received those documents. One word of caution about checking the box if the buyer has received the SSC. All too often, listing agents have had sellers fill out a, shall we say, shorter, less responsive document known as the CAR, Seller Property Questionnaire, or SPQ. If the buyer has received the SPQ as part of an upfront disclosure packet, then the buyer should not be checking the box that they've received the SSC. You must then discuss with your client whether or not the client is going to demand, as part of the offer, that the seller comply with this portion of the contract, which says the seller shall also fully complete the SSC. This is a determination that should be made by your buyer as part of the offer process. I would encourage you to provide both of those forms to your buyer so your buyer can make an informed decision as to whether or not they want all of the information that an SSC provides as compared to accepting merely an SPQ. Are not interchangeable. They serve the same function, but they do not provide all of the same information. Dave, have you seen a marked difference in those claims and lawsuits where the SPQ has been provided as compared to the SSC?
Yes, we will be discussing one later on in the program. I would also, if you would indulge me, I would like to focus everybody on the impact of this acknowledgement that it says the following fully completed disclosure documents have been provided. And the issue that we end up litigating at times is when they're not fully completed, information is not all there, all the answers are not detailed enough, whether irrespective of which form you're using. What is the impact or the potential impact of on an agent of letting that ball go through the wicket, as they say, whether there's a waiver, whether there's an estoppel or not, whether there's still requirements to amend or not, that it's just unanswered terrain. How do we deal with it? By being vigilant upfront. Thanks, Vicki.
My pleasure. One thing I do want to point out is that the PRDS Forms Committee has chosen to put into bold print specified terms in various different provisions of the contract in recognition of the fact that it is critical that the disclosure documents must be fully completed. You'll note it's in bold print. This is not done capriciously. It's done to help serve as a reminder to you as the agents and also to better explain it to the clients. Just because a form of a TDS or a form of a lead disclosure has been provided doesn't mean that it meets the contractual requirements of being fully completed.
Yeah, that's the point. There's a contractual definition, as most of you know, and there's a distinction between PRDS and CAR on what document does need to be fully completed.
So please make sure you do review the documents before you pass them on to your clients, and definitely before you fill out whether or not the buyer has or has not received these fully completed disclosure documents. Paragraph 30B deals with the buyer's default. Now, Dave mentioned that in new construction, the Right to Repair Act has been around for quite a number of years, but it still creates a lot of confusion. A law that's been around twice, if not three times as long, the Right to Repair Act, is the liquidated damages provision. Now, you'd think that something that has been around for, oh gee, as long as Dave has practically been drawing breath on this earth, that it would be clear and well understood and everybody gets it. The problem is that the legislature has crafted language which, quite frankly, has a few holes in it. And when a statute doesn't fully and completely define how things are supposed to work, mistakes can happen. And those mistakes are costly. One thing that has been rather evident throughout the years is that many buyers and even agents feel that the liquidated damages clause, which says it caps the seller's right to recover damages to 3% or the amount that's actually in escrow, that language was intended to mean that if, gee, there's no money in escrow, then the seller doesn't get any damages. Well, let's think about that for just a second. A buyer fails to put money into escrow. That's a breach of contract. Should liquidated damages, the seller doesn't get any money? That doesn't even make sense. And it is unlikely, if the legislature actually thought this provision through, that they would never have intended it to mean that. What they did intend to mean was that if there was less than 3%, for example, only 1% or 2%, then the seller's damages are capped at that amount. There's nothing in the legislative history or any cases looking at this statute which says that the legislature intended for the seller to recover $0 if the buyer's breach is failing to put the deposit money into escrow. Carr has been very leery of tackling this problem. He's decided to take it on. And when we took it on, we tried to come up with something which was reasonable and fair. The language which is highlighted in yellow in paragraph 30B is the new language the PRDS Forms Committee has created. The parties understand, acknowledge, and agree that any failure by buyer to make a timely deposit into escrow of the agreed upon initial and or additional deposits shall be deemed a material breach of this contract. Why is that language in here? Because we want to make it very clear that even though it seems to be a perfunctory act to put money into escrow as an initial deposit, it is something that is critical to the binding nature of this contract. So if the buyer fails to do it, it's a material breach. And subject to the seller delivering the notice to perform, giving the buyer 2 days to correct the default, the seller may, in the seller's sole discretion, cancel the contract and or pursue any and all legal and or equitable remedies, as well as recover any and all damages of any kind, including but not limited to attorney's fees and costs that result from the buyer's breach of this contract. And then here's the magic language, which is so critical to this concept: whether or not liquidated damages has been initialed by all parties. So in other words, if the breach of contract is failure to put the deposit money in, the seller now has recourse after issuing the notice to perform damages. One thing I want to stress here is we put in the steps of subject to delivering the notice to perform as a reminder, not only for this section, but in all other sections where a buyer or a seller has failed to perform their contractual obligations. The other party may not cancel unless and until they to perform, giving the requisite 2 days to correct. New language will serve to make for better contracts and a better understanding of the parties of the importance of escrow. It will also help to protect sellers to recover damages if the buyers have not put in their deposit. So listing agents, pay special attention. This provision is definitely a benefit for sellers, a benefit which is not in the CAR purchase contract.
Vicky, could it be included in some format in the CAR contract?
All that CAR has done, and I'll be getting to this when we talk about the CAR form, is make a recommendation. They did not go this far.
No, but the question I'm raising is this language that we've highlighted and created. Do you believe that it can, with a modification of the paragraph number, be utilized by a seller with the CAR contract?
I believe what you're asking me is, could this language be put into a counter offer if the buyer has used the CAR form, which doesn't have it? Yes, it could be used in that connection.
All right. One other thing that I'd like to point out quickly to everybody is one of the legs on liquidated damages is that the buyer intend to occupy the property. I have encountered recently a number of instances where that is not true. And when it helps me, I don't point it out. When it does help my client, I do point it out. So just bear in mind that in order for liquidated damages to apply, that is a component of that stool, what needs to be there to support it. Thanks.
And I would point out that it's not just a question of whether or not the intent to occupy box was checked. It's whether or not the buyer has an actual intent to occupy. So please be aware of that as well. Moving on to the third change of the PRDS contract. PRDS and CAR have for many given the brokers the ability to opt into arbitrations between buyers and sellers. The language which is agents shall not be obligated nor compelled to mediate or arbitrate unless they agree to do so in writing. Any agent participating in the mediation arbitration shall not be deemed part of the disagreement. That's interesting. We had comparable language. Now, why am I bringing up the CAR and PRDS have done on this? Well, here's the problem. We have a lot of instances where the buyer and the seller are disputing truly a buyer-seller matter. The brokers are at best witnesses. They're not really parties to the actual dispute between the buyer and the seller. It is to the advantage of the real estate professionals to allow buyers and sellers to arbitrate their disputes first. Then, if there's anything left over which involves the agents can come along later. For more years than I can count, certainly longer than my children exist. And in all those years of practice, ever since arbitration became a part of the purchase contract, I've only seen one instance where a broker decided to opt into the arbitration between the buyer and seller, and afterwards the attorneys have had comparable experience. Sellers,
You're cutting in and out.
then you should mute yourself there. Buyer and the seller dispute doesn't need to have the brokers. And that is the fact that recently several judges have ruled that because brokers have the option to participate in arbitration, that they are parties to the arbitration agreement, regardless of other language used. So PRDS decided to end the debate and to come up with language that makes it clear that the brokers are not obligated to arbitrate. The language in yellow, which is in the new PRDS contract, states not only the real estate licensees are not parties to the contract, they are not required to participate in mediation, They may elect to participate if they receive a written demand to do so. That's because many brokers do want to participate in mediation, but they don't want to participate in the arbitration. So the next sentence provides that real estate licensees are not parties to the arbitration agreement. Therefore, it's understood and agreed that the real estate licensees cannot be compelled to arbitrate any or all disputes relating to or arising from this contract, even if they participate in the mediation. We believe that this resolves the debate as thoroughly and as efficiently as possible for the protection of brokers and agents. They seem like brokers might want to participate in the arbitration. The reality is it's not in their best interest. So why give them an option which can only serve to backfire on? Securities cancellation form, we only made one change, and that was necessitated because of the new concept that we've included regarding the failure of the buyer to put in the initial deposits. So we added a new checkbox, and as is true with the purchase contract, we have included a reminder that the seller has to deliver that 2-day notice to perform to the buyer. And if after that period of time, the buyer continues to fail to make the required deposits, the seller has the right to cancel and to pursue any and all damages. So the cancellation form has now been modified so that it works with the PRDS purchase contract. It is not going to work as written with the car purchase contract. If you have a car purchase contract, but there's a counteroffer which is put in the language, as Dave has suggested, from the PRDS form in paragraph 30B, you would then have to modify the language in this cancellation document in any cancellation form that you serve on the buyer, because the car form and this form will not work in that situation. Please. 6 or 7 years, Dave has been complaining in all of his articles and presentations that there's been a cancellation epidemic. And it's not that he's an alarmist, that's what he sees. He sees hundreds and hundreds of developing from cancellations, and he has a day at times, it seems. The secretary is starting to complain about it. So one of the things that PRD has tried to do to help this situation was to create a cancellation of contract advisory. We rolled this out over a year ago. This is on here just as a reminder that if your client try to cancel or the contract, please make sure that you give this form to your client. You can attach it to the cancellation contract form. All you have to do is check the box where the blue arrow is. Form, but the best practice is really to give it to the buyer or seller before they're contemplating the cancellation, so that they know what they can and can't do. We also took a look at the PRDS intent to exchange addendum. Only a few changes were needed. That's only 3. We've added some new terminology to clarify who is trying to get the exchange. We have better explanations if the buyer breaches, and we have a clarification of the optional provision in exchange addendum. It's only 1 page, and I want to point out that it has always been able to be used by a buyer wanting to do an exchange or a seller wanting to do an exchange. It has different forms, and it gets confusing at times This, I think, makes it significantly easier to use because it doesn't matter who is asking for the exchange. We just use this one form. Now, I'm often asked, well, what happens if both buyer and seller want to do an exchange? You know, it's so rare in the world of exchanges. It happens maybe 1% of the time. But if it is going to happen in your transaction, then you will need a separate form for the buyer and for the seller to do their own exchanges. Some of the changes that we have made to this document is, first off, number one, seller or the buyer, whoever is going to be requesting the exchange, that person is now referred to as the exchanging party. That makes it easier. We don't have to say buyer or seller in each of the paragraphs, and it also makes it easier to read the form. The PRDS intent to exchange addendum has always specified that if the exchanging party wants to be able to cancel the contract if the exchange is not possible, well, we had a nice exchange contingency in here. All you had to do was to check the box where the blue arrow is pointing. That buyer or seller would have an exchange contingency. There are, however, instances where the person who is requesting the exchange doesn't want to have a contingency because they're willing to close even if they can't do an exchange. In that instance, paragraph 3 applies and you don't check the box in paragraph 2. Problem in exchange situations is the iniquity in the ability to collect damages. It's always been the case that if the seller defaults and the buyer is the exchanging party, any and all damages caused by the seller's breach. However, the buyer who has breached the contract and the seller is the one who is trying to get the exchange, there has been a limit placed on the seller's ability to collect damages if the buyer and seller believe liquidated damages. It's one of these little hidden gotchas. And it is, I'm aware of one case where because the seller is not able to recover almost $50,000. $50,000, that's the tax liability that she can't collect from the buyer because the buyer and seller had agreed to liquidate damages. So it was cut off to the amount of the deposit. It was far less than the $50,000. So to change that and to eliminate this iniquity between the buyer and the seller, we have a new portion in the exchange contingency provision. Exchanging party and the buyer defaults. The parties understand, acknowledge, and agree that the liquidated damages provision in this contract shall be stricken, whether or not it was initiated by the parties, so that there will be no limitation on the amount of damages that the seller may legally seek to recover that from the buyer's default. This magic language is not in the CAR extend to exchange addendum, whether went for the seller or buyer. They have not eliminated this iniquitous situation. The PRDS has seen this problem in action, and we have risen to the occasion and fixed it. New in the PRDS addendum form, you're probably not even going to recognize it as a PRDS addendum. We made count of 5 changes, and quite frankly, this is one of the most impressive documents that we changed. We have taken PRDS standard addendum form, and we have a multi-purpose form. One of the complaints that the committee had received from the original form was that right after I appeared this addendum, we had the number of the addendum. For some reason, people were not seeing that. So now this form starts off by stating This is addendum number, and this is where you put in the number. I think it'll make it easier on all of the various electronic platforms to do that. Rental agreement could even be an addendum to a counter offer. That's each of those documents that's addendum to, it's going to be called in this document, the document. The term preparing party is used, so whether it's the buyer, lessee, seller, or lessor, and through by just saying the preparing. And that preparing party has 4 new options. The first is to request an extension of time for close of escrow. The second, to request an extension of time for contingencies or contractual obligations. Third is, I think, really important. Reminder that time is still of the essence. So the fact that you're giving an extension does not change that. And finally, number 4, there is a specific provision to make sure that there is a revocation in this document. Now, CAR had created a revocation of addendum. Not in its addendum form, only in their amendment form. CAR has also got a document to help parties extend the time of close of escrow, as well as contingencies. But they're all in separate documents. We've got in one form, and this one PRDS form is equivalent to CAR's ABM or addendum form, the AEA, the amendment of the existing agreement form, as well as the extension of time addendum. So I think you will find it a lot easier, regardless of what you want to do with an addendum. It's pretty well stated here. And of course, as always, there's plenty of blank lines if you want to play lawyer. In PRDS exempt seller disclosure, just 2 changes. And it may not seem like a big deal, but we've added a special caution, and we've emphasized that sellers should attach all documents. Now, in the PRDS SSC, there are multiple instances throughout. Seller is told to attach documents. We do that because one of the problems that we've seen in claims and lawsuits is that sellers simply don't provide the documents. Even seller property questionnaire has been revised, and now it states in paragraph 5 that the documents that the seller is to provide are those whether they prepare past or present, including a previous transaction. And the seller is told to provide those documents. So all of this is in the SSC and the SPQ. A comparable approach in the SSC disclosure. So we modified it. Now there's this new seller caution right at the top, which first off reminds sellers that they should be reviewing the seller advisory regarding completing the real estate transfer disclosure statement and other seller disclosure forms. That is the best advisory to enable sellers to understand their disclosure obligations. CAR has a comparable form. It's called the Disclosure Information Advisory. Whichever one you use, what's important is making sure that sellers get this before they start filling out a form, including the exempt seller disclosure. The second change is what we specify now, that if the seller has said yes to any of the questions in section 1 or section 2, that they are to attach all documents. What that PRDS has, as compared to the one that CAR has, is PRDS was broken out as a separate question. Are you seller aware of any other material facts, information, or documents that may affect the value or desirability of the property, which are not otherwise disclosed in writing to buyer? This particular question is found in the PAR form, but it's tucked in as question 1J, and it gets missed. Having it as a separate question emphasizes the importance of, which is yet another reason why the PRDS form is superior to the PAR form. PRDS SMSCA, very little needed to be changed. In fact, we just made really one change. Yeah, we changed the date because whenever we roll out a new form, we change the date. And up in the introduction. Some local jurisdictions have already or are contemplating requiring that existing gas lines to residences be eliminated. And some communities are prohibiting remodeled homes and new construction to add gas lines. Now, this is going to come as a major shock to a lot of buyers who are buy a house. It has an electric range, it has other electric features, but they want gas range. They want that Wolf heavy-duty gas range. Well, that may not be possible in a lot of communities now and in the future. And so therefore, added to the PRDS advisory regarding future repairs, replacements, and remodels, we have added elimination of gas lines. Now, if you know a client who wants to add a Wolf range to an existing electric range home, or they want to add lines, please make sure that they check out the viability of doing so during their investigation contingency of the property, because as it looks now, more and more communities are going to be eliminating the possibility of having gas lines to residential property. Now that I've told you what's new in the PRDS forms, let's take a look at what's new in the CAR. CAR undertook a massive change to the RPA, which came out in December of last year. Many people, rightly or wrongly, assumed that it would take at least 2 years before CAR made any other changes to that document. Well, interestingly enough, CAR has made over 3 dozen changes to the RPA, which quite frankly, I find to be rather mind-blowing, because so much time, 3 years in fact, was spent putting that first document together. The fact that they made 3 dozen changes seems really wild, but they did. I'm not going to talk about all the little ones. I mean, some words here changed. Some of it was good, some of it was bad. Some of it didn't make any sense. There have been some significant changes to the CAR RPA, especially with respect to the 3-page starts off the RPA. For financing provisions, now to have a fully completed finance contingency, you need to specify the maximum amount of points that the buyer will agree to pay or secondary loan. The importance of fully filling out the finance later in the program. But be aware that now to have a fully completed contingency, you must now specify the points. What we change to the grid is a new section in which the seller agrees to pay the buyer broker's or broker representation fee. Now, this odd addition in many of the most instances, there isn't a buyer broker agreement. However, CAR is anticipating that with some of the changes to the ethical provisions in because of the federal government suing NAR, that there of brokers using buyer broker representation agreements. Carr wanted to create a mechanism whereby the seller would agree to pay some or all of the amount specified in the buyer broker agreement as an incentive for the buyer to enter into a purchase agreement to purchase the seller's property. Now, this has nothing whatsoever to do with what amount of money has been offered through the MLS as consideration to a cooperating broker. This provision, if the buyer broker compensation agreement is in place. And number two, the seller is willing to pay some or all of what was agreed. If A and B are true, then Carr says, see this additional new form. Has nothing whatsoever to do with the amount of money offered through the MLS. It strictly relates to when the buyer and the buyer's broker have entered into a compensation agreement, and the seller is now willing to pay for some of that. We probably won't see this for some time, but this is what's going to happen. If there is a buyer-broker agreement and the seller has been made aware of it, and the seller says, yes, I will pay for some or all of that compensation, then our new form, the seller payment for buyer's broker. This form is not needed to confirm of offering through the MLS. This strictly relates to the seller agreeing to pay for amounts specified in a buyer-broker compensation agreement. Now, having said that, I want you to pay attention to how this form is formatted. It specifies in paragraph 2 that this particular payment is an inducement for the buyer to enter into the purchase contract. Well, if it's an inducement for the buyer to enter into the purchase contract, then seller and listing agent see that buyer broker compensation agreement before or after the buyer presented their offer. I believe it needs to go before, because it can't be an inducement to enter into the agreement unless the seller knows that such an agreement exists. So, although it says in paragraph 3 that a copy of the buyer broker compensation agreement can go into escrow, it really needs to go to the seller for any of this to make sense. Please take a look at paragraph 4. I believe it's ambiguous. I've tried to work it out mathematically a few times. Essentially, what they're trying to say is that at no time is the amount that the seller is going to pay larger than the amount that's in the buyer broker compensation agreement. Sure how that would work for them, but that's what it provides. One of my other concerns is that since Carr is now providing that the seller is paying something which was an agreement, which was originally not offered through the MLS, but actually part of the buyer broker compensation agreement, they're saying it's going to be a transaction cost. Pay attention to this, ladies and gentlemen, because if this structure remains as is, some lenders may actually take that amount and deem it a credit. So please check with lenders before you go forward with this particular payment structure. I believe it's been ill-advised. Carr, after it became aware of the countless problems with buyers' failure to deliver the deposit into escrow, not come up with a final resolution. They simply have a new. Buyers need to consult with a qualified California real estate attorney regarding possible liability and remedies if buyer fails to deliver the deposit. This is not a solution. This is a recommendation. And in all likelihood, the consultation with a qualified California real estate attorney will occur too late in the process. That are made to the RPA, something which is in the PRDS purchase contract, and that has to do with the associated hardware and laws, which when we rolled out our analysis of the car purchase contract, we pointed out that this was an omission. They've now corrected that omission. Very happy to see that change. Another new paragraph in the car RPA is paragraph 11M, and it's designed solely to deal with the existence of solar panels or solar power systems at the property. Now says that the seller may use a questionnaire going to be the standard of care when using the car contract for properties with any solar panels or solar panel systems, now within time specified in paragraph 3 and 1, which is for disclosure of certain items, delivered to buyer all known information about solar panels or solar systems. Do that is to use the new solar of a new car form. Is the new solar advisory and questionnaire the car has created. The first page has a great deal of good information about solar systems, hero and pace liens, much of which is already contained in the PRDS Santa Clara County Advisory questionnaire, depending upon whether or not the items are owned or leased. A lot of interesting technical questions. Unfortunately, it doesn't really put a lot of emphasis on the seller providing the documents regarding those items. Instead, the seller is going to have to review all of the documents to be able to answer the form. What's also missing from the solar panel and solar system questionnaire is an important question, and that is the one that happens to be contained in the SSC, which is, are you aware of or have you experienced any issues, conditions, and or problems with the use, leasing, or ownership of the photovoltaic solar electrical systems. Now, it's all very well and good to provide the documents and to provide the information. So many sellers have traditionally had problems with these systems, and nowhere in the car forms does the seller have even a hint of problems. Even though it's shorter and simpler to use with respect to solar, the PRDS form is actually superior. I am also concerned about the significant risk with having a separate form, because over the years, every time car rolls out another separate questionnaire, those questionnaires don't get used. So be aware that if you are using car contract and the property has solar panels or systems, you do need to put solar advisory, even though it doesn't ask some of the most important questions. There are some other important issues that CAR has not fully fixed in the RPA. As we explained when we rolled out our incorporated into the contract, the statutorily required notification with the fair housing laws. CAR chose that. They have merely created a checkbox and a reminder that, gee, you need to add that. So the FAR has not put that statutory advisory into the contract. The RPA is actually 17 pages long because you have to add that addendum each and every. Brokers have been advised. There's a lot of confusion still as to how to handle late delivered documents. And as I pointed out, FAR has also not eliminated the problems of agents and brokers being ordered to arbitration because it just didn't go far enough in that section of the contract. Probably the thing that is most FAR still has no separate insurance contingency. Way too many buyers upfront packet that is so prevalently used in Silver. Buyers feel comfortable about waiving their inspection. However, in the FAR contract, part of the investigation contingency. So be aware, this is a major problem with the RPA, and it has been a problem with buyers who can't get a loan because they can't get the insurance, do not have a contingency readily available for the structure of the contract. FAR also has 8 other new and revised forms. Buyer representation compensation agreement. Excuse me, and cancellation of buyer representation. Those are the 3 that relate to representation and compensation. The other 5 new forms all relate to property management activity. Stress that although CAR has provided a lot of excellent use in landlord-tenant situations, if you and your brokerage have not been approved to handle not undertake any type of activities other than your basic of a property. Do not take rent. Do not be the contact person. A property manager. I spoke to an expert on DRE matters on Monday. DRE still spends almost 2/3 of their investigative time reviewing the property managers. Catches most of these property managers unaware and potentially costs them their license is the accounting principles that must be followed. There actually have to be 3 different accounting documents used when you are property manager. If you do not understand how to do that, do not become a property manager. It is very dangerous. Brokerages and agents have lost their licenses because they were performing property management services without knowing how to do it safely. Our rental property owner disclosure has also been updated. That's good. That's the good news. News is the document is an absolute trap for the unwary. The committee that put this form together decided that this should be a property owner disclosure from the property owner, previously known as the landlord, to the listing agent or property manager. when you look at where they are on the second page, note, gee, there's a line or two for the property owner as well as for the broker. But the buyer or tenant, why is that significant? Because now this form, if it is used by a property manager / listing agent, not designed to be given to the buyers or the tenants. So that's in this form supposed to go to the buyers or the tenants. There is no, and that's why it's a trap. If you want a property owner disclosure, I urge you to go online and check out the one that here it is filled a couple of years ago. First off, ours is far more thorough. Second, and most importantly, it's designed to be given to the people who need to receive the disclosures, not the broker. There are lots of new laws for 2023. One part does quite well is they do a summary of all new laws. If you go onto the CAR website and put into the CAR search box 2023 new laws, you'll find a 31-page summary. Yeah. That means there's tons and tons of new laws. CAR sponsored several bills facilitating the building of ADUs, and one of them I have a little bit of a problem with. To not consider added units. For those of us who live on cul-de-sacs and keep seeing additional ADUs, at the parks, because even technically within 1.1 miles of the park station, everybody has a car. Making parking in the cul-de-sac difficult. But you will see more of that. Also, a new law that allows residential housing to be built within areas that are specifically zoned for office or retail space. This may also present problems depending upon the infrastructure that is available in those zones. And finally, one good thing I believe is that there are some landlord-tenant protections for victims of domestic abuse. But I do urge you all to go online and review that 31-page summary that CAR has prepared. The last part of our program deals with urban myths and realtor myth information. We have brought to you today renowned barrister on this topic, the one and only Mr. David Hammerslow. David, please tell us, what is an urban myth?
Well, before I do so, ladies and gentlemen, I want you to all appreciate that I am now in front of the Queen's bench here, and you are looking at the head of silk here in this chamber. So what is an urban myth? We've had some fun, Vicki and I, talking about these, and it is a commonly held belief or piece of information that is circulated as though it is true, when in fact it is not true. And Vicki just loves Gershwin, and in the words of Mr. Gershwin, it ain't necessarily so. So with that, let's proceed and have some fun, sometimes known as realtor law or realtor, I love this one, Vicki, mythology. There are many common real estate misconceptions that need to be eliminated. So please provide me with myth number 1. Adding the words "as is" to a purchase contract protects a seller from buyer's claims. In other words, ladies and gentlemen, it is a bulletproof vest. We have nothing to worry about. And the answer and reality is, false, 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 false. All right. So we all know that there is as-is language baked into all of these contracts. And yet people continue to ask me, well, is it an as-is contract or not? Do we need an as-is addendum? Well, I think the reality is that it is better with an addendum. We certainly have more clarity about the scope of that. But really the best way to protect the seller from buyer's claims is to have the seller make a full and complete disclosure of any fact which affects the value, use, development, or desirability of the property. Please do not misrepresent anything. Please have your sellers make sure they don't. We have some fantastic advisories on filling out these disclosures. I seem to recall that our dear Madam Head of the bench here drafted one of the first one of those. Vicky, how many years ago? Long time ago. So that, and it's bundled, as I understand it, with the disclosure forms, but they need to be read. We've written articles, we've given seminars about what words to look out for, what words not to look out for. And just, one last thing, I had a case not too long ago where neither agent reviewed the disclosure documents. They left it up to a TC, they left it up to a manager. Neither of those individuals had even done a visual inspection of the property. So you just need to be careful about what you are passing off, on to others. Lastly, why do we want to make sure to allow the buyer to have unfettered access to the property? Because of a appellate decision years ago, 1987, I believe, 86. Well, I was off for a year, Your Honor, give or take. Shapiro versus Who, that said that the enforceability of an as-is clause might be jeopardized if the buyer does not have access to the property. So let us move on to myth number 2, please. The absence of loan terms in the financing clause has no potential impact on the buyer or seller. Ladies and gentlemen, I don't care which contract you're using, but for whatever reason, I have not seen interest rates included in these contracts in a while. And I don't know whether that was a function of, the market we were in, whether it was a function of non-contingent, contingent-free offers. People really were just going out to get loans to the extent they could, but this provides a level of protection to not only the buyer, but also the seller. So is this true or false? It's false. So what is the reality, please? The reality is that Vicky and I could argue both sides of this argument. And one outcome is we don't have a contract at all because we're missing a material or essential term. The second outcome is there is no contract, or there is a contract, but the buyer doesn't have any basis to cancel regardless of the loan product or interest rate offered by the lender. This really can impact not only a buyer, but let's face it, it impacts a seller. Because if a seller can't get a buyer to complete the transaction, a failed transaction is what? A problem. We're back on the market is declining. Is liquidated damages clause initialed or not? One little thing that I'll leave you with on that is it in the seller's best interest to initial liquidated damages in a declining market? All right, myth number 3. Create certainty by filling all terms in. Yes, and as Vicky pointed out, in the new car contract, you need to get points as well as interest rate, filled in there. It is conceivable that somebody will make the argument, we don't have a contract because there's been no meeting of the minds on a material fact. All right, myth number 3. If there is no deposit, the buyer has nothing at risk. We have been talking about this now for some time. You've heard what the change is to the PRDS contract. This is also false. Although some people have interpreted the liquidated damages clause as validating this concept, the reality is that if the buyer fails to make the agreed upon deposit or deposits, the buyer is breaching the contract. The question is going to be whether a decision maker, likely to be an arbitrator, is going to reward a buyer for doing so, or simply say that the seller doesn't get to recover anything. And I also need to caution you, this whole area is potentially impacted when somebody cancels, i.e. the buyer cancels, before this issue has been addressed by the seller through a notice to perform. So what's the argument? I wrote an article on this. Please take a look at it. It discusses the consequences and ramifications of that myth. Myth number 4. This is one of Vicky's favorites. Real estate licensees do not need to read any documents as long as the documents are delivered to the client. There is some sort of, it's false, apparently. There is some sort of mythology out there that I think has the acronym RDR. Am I correct? That's a Vicky acronym. Realtors don't read. All right, what's reality? Reality is California law requires that fiduciaries, which we are when we are in an agency relationship, must learn the relevant facts as part of representing their clients. Can that be achieved where the agent does not read all of the documents? I doubt it. I doubt it. We have a duty to learn. We have a duty to inquire. The DRE has provisions about these issues, and this is a big myth. So what is the erroneous acronym? Realtors don't read. Of course, now we know they do. And what is the correct one? Realtors must read. Realtors must read. All right. Myth number 5, please. A really smart but unlicensed TC or assistant can fill out contract and disclosure documents, I might even add, and review them to determine if they're fully completed. Is this actually true, Your Honor? All right, we got enough sound effects. All right, what is the reality here? DRE regulations are clear that only the real estate licensee can perform licensee activities. Therefore, the assistant cannot prepare contract language or disclosures. Look, when does this actually come up? Well, it comes up, unfortunately, when there's a problem and a claim, and you start tracing who actually reviewed the material, who filled them out, and how much time people spent, etc. So it does turn up, ladies and gentlemen. It does. What is myth number 6, Vicky? It's okay to make disclosures in the MLS because that information is always given to the buyer. True or false, ladies and gentlemen? And the answer is, Your Honor. Whoa, look at those graphics. False. What is the reality here? The MLS information is not always provided to the buyer. The buyer would need to acknowledge receipt in writing of all information put into the MLS. And the best practice is to disclose all agent information in the AVIT. Now, for years, when I have been preparing my clients for deposition, and we are going over what documentation they reviewed and relied upon in making that very important decision, whether to make an offer or not, it's really remarkable how many of my clients have always seen, reviewed, and relied upon the MLS without any prompting or suggestion by me at all. All right, what's myth number 7, my friend? Contract terms included in the MLS are automatically included in the purchase price. All right, I think most of us, I hope, have got this one. False. What is the reality here? The reality is that certain personal property items are excluded. The sale is subject to probate court approval, or specifying this in the MLS, or that this is a short sale and or that the buyer must use a certain form. These are interesting pieces of information, but they're not necessarily binding unless the buyer and seller agree to them in the purchase contract. So what's the solution that we've always come up with? Put it in the contract. Don't leave it left out there in marketing material or MLS land. All right, myth number 8. An agent can safely advertise that any or all personal property is included in the sale. True or false? And false. You know, I'm beginning to wonder whether any of these are going to be true. All right, what is reality? Although the seller is only obligated to include or exclude items specified in the purchase contract, an agent may still have liability for false advertising, misrepresentation, and or a violation of the code of ethics. The best practice tip that we are giving you is don't advertise the personal property, promote the real property. All right, myth number 9. The appraisal contingency allows the buyer to cancel if the buyer doesn't like the information in an appraisal report. True or false? False. Now, this is an interesting one, ladies and gentlemen. This is where it pays to read the words in the contract. So the reality is both the CAR and PRDS contracts limit the appraisal contingency to the buyer's approval of property value, not any other information. If the property appraises, but the buyer does not like any other information, the buyer will only be able to cancel if the inspection contingency or investigation contingency is still in place. Hopefully, we're going to start seeing that in a few more offers. All right, myth number 10. This is mine. Cancellation by the buyer shortly after contract acceptance means that the seller has no damages. I'm going to tell you right now, I don't even need the Queen bench to tell me the answer to this one. Ladies and gentlemen, a breach on day 1 is the same as a breach on day 30. It just doesn't matter. If a buyer cancels without a good faith basis for doing so, they are going to have potential liability. The seller is entitled to pursue their claim, whether it's for liquidated damages, damages under 3307 of the Civil Code, which we've described up here, etc. They'll also be able to go for attorney's fees. I cannot tell you how many buyers and their agents in the last 1.5 to 2 years have said, well, I canceled right away. There's no harm. Well, we all know that that's not what happens. In the real world, how many times do we actually successfully get into contract with some of the people that were previously interested without having to compromise price? They're not happy. They got jilted and left at the altar. They're not going to play the same way. All right. Myth number 11. All trustees of any trust that is selling real property have no disclosure obligations. This is one that we've all talked about. False. First of all sellers of property have a common law duty to disclose all known material facts. There are also several statutory disclosure obligations for a seller that exist regardless of how title is held. We've got a couple of them up there. Then, If a trustee is exempt from the TDS, the disclosures contained in the ESD are legally required. Not all trustees, however, are exempt. We've put this up before. These are the requirements. If the trust is a revocable trust and the trustee is a live person, and either the trustee has owned the property in the trustee's name or has lived on the property within 1 year of sale, that trustee must complete the TDS, an SSC, or an SPQ, the NHDAS, and the FHDS. So think about it this way. I put my property in a trust. It's revocable. I think I'm still alive and breathing. Sometimes I don't know. And I'm still living in the property. Do I get a pass? No. All right. Myth number 12. Oh, yes. A buyer is entitled to a price reduction if the market value of the property declines after contract acceptance. All right. The reality here is all of you know that this is not the case, but apparently a lot of clients don't, because I am still fielding that question. So I've taken to responding as follows. If the seller had come back to you when the market was rising and said, will you pay more money now because the market has gone up? What would the response have been on the part of a buyer? I don't know that anybody would be giving them a bunch more money. So this is just common sense, but I think what we really need to do is to disavow our clients, buyers primarily, of this myth. Changes in the market do not create an automatic adjustment in the agreed upon purchase price. All right, myth number 13. Agents can always trust that assessor's records accurately show the property's size and legal number of bedrooms and baths. I bet you I could make some money on this one. How many people think this one is true? How many people think it is not true? And, Your Honor, what is the answer? Patricia raised her hand. We'll get your answer in a bit. False. All right. Now, the reality here is this. What you can trust as a result of the assessor's records is how much the assessor thinks the value of the property has been impacted by whatever improvements are created during its history and ownership. The assessors often include illegal added space so as to charge more property taxes. So what you have to recognize is the planning department and the building department and the assessor's office don't necessarily sync up completely. The assessor goes out and looks at the property for one reason: money. Money. They are simply determining what improvements have been done. Now, ladies and gentlemen, if you have an issue over the legality of an improvement, the assessor's records can help you date that improvement to determine whether or not it occurred prior to the advent of building codes, which would then make it arguably legal non-conforming. But do not, the legality of bedrooms and baths is a function of their compliance with planning and building and the issuance and finalization of permits. Square footage and lot size are subject to several variables and can only be determined by experts, and never assume the numbers used by the assessor are accurate. Now, there is a beware here that we want to bring to your attention. Many of us look and rely upon property profiles or MLS property reports or other similar computer-generated data. These documents are generally based on the assessor's records and are thus not reliable for the legality of bedrooms and bathrooms and other add-ons or improvements to the property. I'm working on one of these right now, and it's remarkable. I'm hoping that the other lawyer doesn't understand this distinction. And if he does, and I get a general release, I'm home free for the seller. All right, myth number 14. An agency relationship does not exist if I did not provide, sign an agency disclosure, and or if I did not get paid. Well, that is definitely false. All right. The reality is providing and signing an agency disclosure form is not the only means of creating an agency relationship. Agency can be created by words and actions. And the fact that an agent is not paid does not mean that there is no agency relationship. Bottom line is, agency, in my vernacular, is a question of fact. We look at what people said, what they did. You've also got concepts of ostensible agency that may come into play. So don't fall for this myth. All right.
I have seen this pop up when agents are quote unquote doing an accommodation. They're helping a friend or relative, but they don't consider themselves to be an agent, and the broker are not listed in the agency confirmation. They didn't give the agency disclosure form, and they pay, but they give lots of advice as to what to put in the purchase contract or how to structure other negotiations. Is that the kind of situation you're talking about?
Absolutely. Absolutely. Thank you. The court has weighed in, given us a brilliant example. I would like to say that, all right, Vicki and I have had a very close relationship that I have often characterized as a wife-husband relationship, but we don't have any marriage certificates or anything. Don't shake your head. Don't even try to ignore it. Anyway, ladies and gentlemen, all kidding aside, the piece of paper doesn't dictate whether you are or not an agent. What you said, what you did, and quite frankly, what the third party, how they received it and how they acted on it and what you acted on is going to say a lot more about that. All right, myth number 15. Delivering current reports. What I mean by that is home inspection, pest inspection, roof inspection done in conjunction with the listing, or marketing of the property, satisfies the seller's obligation to give the buyer historical documents. This has been the single biggest claim that Vicki and I have seen in the last 6 months, a year. Even though CAR took what was a question on the last page of their SPQ, put it on the front page, paragraph 5, expanded the definition. I cannot tell you how many times in the last 6 months I have read inspection reports in conjunction with the listing, or see current home inspection, pest inspection, roof inspection. Those are not only, they're not historical documents. The definition and the scope of this is much broader, much broader. Any seller documents that contain information regarding the property's use, development, value, and or desirability, which are in the seller's possession, should be provided to the buyer. And the agent should be telling the seller, the rule is, you got it, you give it. Another Vickyism that we've heard for years. This is absolutely a devastating problem. It can lead to cancellations. It can lead to claims after escrow closes. It is simply a problem that continues. I have tried to write articles about this. Obviously, I need to expand my readership, but this literally continues to be a problem. less so with the SSC because it constantly tells the seller what they need to provide. The problem with the paragraph 5 still remains. It is a long, convoluted sentence with a lot of clauses and provisions in it, and people just don't grasp the scope of it.
So when
So
you're talking about paragraph 5, you're talking about the introductory paragraph 5 of the SPQ, correct, Dave?
yes, yeah, just pull it out. I got it right here. But the point is, it talks about historical disclosures. Here's the other thing to remember. If you as a broker or an agent have had any experience with that property, there are some DRE requirements that documents from prior transactions need to be retrieved. So if the seller provides historical documents, the agents do not have to provide any other documents. True or false? False. Simply because the seller has provided documents does not eliminate the broker agent's responsibility to provide all of the documents that they possess. Second, brokers must keep their transaction documents for a period of at least 3 years. The rule that we are talking about extends beyond that if you have those records accessible or available. We can get into some interesting discussions as whether that is at an individual office level, if that is at a broker level, how are they retrieved, who has access to them, all sorts of interesting issues. But the best practice is for each listing or sale is to retrieve all the prior files and provide the historical documents to the buyer, regardless of the age of the documents. The rule, once again, is if you got it, you give it. And if there is not a procedure in place within your office for that to take place, then please go to your manager right away and make sure that gets implemented, or go to your own qualified California real estate attorney to discuss it. All right, what have we got here? In current lawsuits, the failure of a seller and or agent to provide the buyer with all historical documents is the biggest. This is the gotcha. This is the one fact that lets the buyer win either big money or manufacture, ladies and gentlemen, a way out of the deal. You need to give me an amended disclosure. You have not given me all the historical documents. So that is how that gets done. All right, Vicki, myth number 17. Escrow automatically determines who is to pay government required point of sale, government required fees and costs of inspections, reports, and corrective/remedial actions based upon local custom. True or false? Yeah. All right. Here is why we wanted to bring this to your attention. I told you that I am seeing repeatedly loan clauses without adequate loan terms. This is something else that I repeatedly see in the grid, especially. These two questions are being overlooked, and I have used them to get a buyer out of problems where there were point of sale issues in the community or jurisdiction. So no such practice exists. The purchase contract must specify who is obligated to pay those fees and costs, and those expenses are negotiable. If not, it is arguable that either, once again, no contract because no meeting of the minds, or there is an ambiguity and the buyer may have to pay for all of those costs, since the contract interpretation protocols are that any ambiguity is construed against the maker of that ambiguity. All right, myth number 18. What the neighbors tell agents is just hearsay that does not need to be disclosed to buyers. True or false? False. Do not classify information as irrelevant or hearsay, regardless of the source. The best practice is to disclose the statements in the other section of the avid using the following format. On such and such a date, I was advised by the name or identity of that person, the following information. Please make it factual. I'm also going to suggest to you that if there is anything in writing, please retrieve that so that your disclosure is consistent with what was said or provided in writing. We obviously want to avoid opinions, adjectives, qualifications, downplaying it. Broker and agent have not and will not investigate or verify this information. Buyer should investigate. That is how we deal with this. All right, myth number 19. Making a non-contingent or contingent-free offer is the only way to buy property. True or false? This is a sort of a slippery one. All right, what's reality here? This might be true in some markets, in some areas, but it is not a universal truth. Depending upon the number of homes on the market and the number of buyers vying for any given property, market conditions, and buyer needs, not preconceived notions impact the type of offer that should be prepared. Why are we bringing this to your attention? Because I am still seeing non-contingent offers in this market without any competition. And I asked the client, why? My agent told me that's what was the norm. So just be careful. Give buyers the market conditions advisory form before writing up the offer. All right, Vicki. Myth number 20. Emails are private, so you and your clients can safely say whatever you want. This applies to text messages as well. True or false, ladies and gentlemen? False. The reality is emails and texts can exist forever. They can be forwarded, cannot easily be withdrawn, and are easily discoverable in claims or lawsuits, even if erased. What is sent in an email can haunt you and your clients in all sorts of actions, including ethics claims. So what do I do as a lawyer? I ask for the communications between the agents, but I'm also asking for the communications between my clients and their partners or their agent. Why? Because I want to compare the two to see if people are talking consistently or inconsistently. So if you're saying one thing to your agent on the, what you think is privately, but your agent is communicating something entirely different to the other side, arbitrators and judges don't like people that talk out of both sides of their mouth, ladies and gentlemen. So just be careful about what that is. All right, Vicki, please tell us what the best practice tips are for emails.
Thank you, Dave. Well, there's quite a number of them. And I have to tell you, this is true whether you're dealing with real estate or even communicate family members. So these are just general good practice tips for emails. Don't hit that send button without rereading and checking what's written. What I want to start looking for is proper grammar, professional language, and sentences that have a complete thought. It's truly amazing serving as an expert and reviewing the email communications between the parties. There are times when the language is so juvenile, it's laughable. And why is that important? Because if you do not present yourself in a professional fashion in your emails and texts, then or any other trier of fact like a judge or a jury to determine that you button, check to see who you are responding to and who you are often received communications which were clearly meant just for me, but someone hit the reply all, and therefore the snide comments that my client wanted to make to me were distributed to. Not a good idea. So avoid using that reply all unless you want everyone who's listed up to receive your input. When you are hungry, angry, how flippant we become in our responses if we are hungry, angry, or tired. 3, do not forward without checking what additional emails and documents are attached. Sometimes when you read through the long chain, you find that there was some private and confidential communications. I've even had lawyers send me stuff which included their clients' comments. Not a great idea, but they weren't following these best practice tips for emails. Finally, and most importantly, please remember that the DRE expects to see all agent emails regarding the transaction in the broker file. One good step to make sure that they actually copy the broker or whoever it is who's putting documents into the broker file, whether it's electronic or in paper. Upload into the broker file. Remember, messages are anything more than ephemeral, meaning anything more than just, I'll see you for lunch, or we're meeting at 12 o'clock. Those text messages must also be included in the broker file of the regulations. So many times the emails can help, but oftentimes they are written and who they were sent to. So please make sure you're following all of these best practice tips. Now, Dave went through 20 myths. Sounded like he was lisping because the word myth doesn't sound good. But there is one truism that I do want to point out. And if you cling to any or all of Dave's 20 myths, you're acting foolishly. And that foolishness can cost you reputation as well as your license. So hopefully going through all of the myths, of all 20 of them, have given what's true and what's. All of you are going to be following our advice, and any final word?
Yes, I would like to thank you for all the time and effort that you always put into these slides. Ladies and gentlemen, it takes a lot of time for Vicky to pull all this together. I appreciate it. I hope all of you do, and I think you do. But thank you very, very much for what you do for all of us.
Well, thank you, Dave. And my last legal aid for so far. I will be formally retiring at the end. I don't want to, but health issues are mandating it. So other than saying goodbye, I just want to say cheerio. And that goes on to Paul.
Thank you so much, Vicky and Dave. And I think, we had some questions, but I believe they've been covered. But most importantly, I just want to thank you, Vicky. In the 10 plus years that we've got to work together, you have taken us to a level and a standard that is the envy of realtors throughout the state of California. You protected your ducklings at CB, and you transferred that standard of care to our members and SAMCAR members. You'll never know how much we value you. And Godspeed. And we know that we'll see you around. And it's interesting. We have Vicky and Dave have been doing this since at least 2015, twice a year. And it's always been, well, we're not going to do it next year. We're not going to do it next year. And then COVID came up. And, this may be the hard stop, but there will be other iterations and other opportunities for us to continue to share Vicky's wisdom and guidance as we move forward. So thank you so much.
And
Yes.
With that, take care, be well. Happy Thanksgiving coming up and happy holidays.
I hope everybody voted.
Yes. And you still have time to go vote again. So
Paul, if there are any Q&As that did not get answered, just forward them to me and I'll try to deal with them.
will do. There are about, there were a lot about exempt sellers, one about the new construction contract. And so we'll definitely
get them over to Molly and me, and then I'll take a look at them.
Okay. Thank you so
All right.
much.
Thanks everybody. Vicky,
Thank you.
Vicky, the only deal today was I tried to tell you were cutting in and out. There was something wrong with your mic or something.
Yeah, it's when more than one person has the live mic, mine cuts in and out. So
And I think I would be remiss, but Vicky is doing this with a cold, so her voice is not as forceful and authoritative as it usually is. It was still pretty damn authoritative, but I think that affected it as well. But
thank you, Paul.
I will miss our little gatherings in this COVID environment, but we'll be together soon.
Okay.
Take care.
Great. Thanks.
Vicky has made a curated deck of slides available for attendees who are in the meeting. And if you would like this slide deck over the next few days, please email me, pcardis@silvar.org. Vicky, that is the only way to obtain a copy of the